Brenda Schleiss. I'm an estate planning attorney at the law firm of Angermeier and Rogers in Milwaukee, Wisconsin. In this video, I'll give a brief overview of how no contest clauses work in wills and trusts. Now, a no contest clause works both inside of a will and a trust, but for purposes of this video, I'm going to use the word will. But keep in mind that no contest clauses are routinely used in trusts as well as wills. A no contest clause is also called an interim clause or a penalty clause. It's language that's added to a will that says if anybody is a beneficiary of the will and contests the will or tries to get more than they're entitled to, that person will instead receive nothing. In general, if our clients don't want to include a certain person, they simply leave that person out of their will or trust. Therefore, if an adult child is cut out of a will, there's really no purpose in including a no contest provision because that adult child wouldn't receive anything under the will and therefore has nothing to lose in contesting the will. So it's a carrot and stick thought process. This only works if somebody is receiving something under the will. Otherwise, the no contest clause has no stick because there's no carrot for the person to lose. Additionally, under Wisconsin law, a no contest clause might not be enforced if the court determines that the person bringing the lawsuit is an interested person and that they had probable cause for bringing the lawsuit. An interested person is someone who would receive property upon your death because they're beneficiaries in your will. Also keep in mind that interested persons are people who would receive your money or your assets if you pass away if they didn't have a will, so spouses and children are included in this category. If someone had a reasonable basis for challenging your will, the no contest clause might not be enforced. So even if the person brought a lawsuit and lost, the court might say that this person had a reasonable basis and therefore would still receive whatever it was that they were entitled to under the will. So that person could contest the will, lose the challenge, and still receive whatever it was that they were to receive under the will. So when would one use the no contest clause? When a person to be included in a will is a known troublemaker, it can make sense to add a no contest clause to your will. A child who stirs up trouble, for example, may be less willing to challenge your will if they know that they'll receive nothing if they bring such a lawsuit. So the no contest clause may encourage somebody to not challenge your wishes if they know that they won't receive anything under your will. Knowing whether a no contest clause will be helpful for you takes knowledge of the law and understanding of your personal situation. If you have further questions or are interested in discussing the topic, please contact us at Angermeier and Rogers, and we look forward to answering your questions.